Judicial Council. According to Section 63 of Judges Act, everybody can file a complaint against the judge, and the Judicial Council may investigate any complaint or allegation made in respect of a judge of a superior court, and according to Section 65(1), after an inquiry or investigation under Section 63 has been completed, the Council shall report its conclusions and submit the record of the inquiry or investigation to the Minister. Despite of this clear law and beautiful sentences written by Chief Justice in the Judicial Council website, the system filtered and disabled this council by review procedure. In this system, as well as Supreme Court of Canada, Superior Court of Ontario, Court of Appeal for Ontario, and Justice of Peace, review, action, and judgment don't depend on law and evidences. It depends on who the complainants, litigants, and judges are. Review process decide which complaint may investigate and go to council for conclusion and ignore the rest. The lawmakers decided about the combination of Judicial Council to be impartial, but acting Executive Director of Judicial Council wrote to me that the Council's review procedure provides an entirely screening process of complaints that falls under my responsibility. This means that he or she thinks that can decide on behalf of the Council. I filed 2 complaints. I asked the Council to review the questionnaire of a judge which was appointed as a judge of Superior Court of Ontario while there was an action against him in that court, and he filed a motion to dismiss action against himself in the same court who he was a judge of that court, and another judge of the same court made judgment in favor of her colleague. I attached evidences, but they ignored it without investigation by counsel. I also filed a 19 pages complaint against the judge with 258 pages supporting documents and evidences which had serious allegations. First review panel returned my complaint with excuse that we don't appeal the judge's decision. When I explained for them that I am familiar with law and don't complain for appeal, rather I asked to remove him because of serious misconduct which is dangerous for justice. Without investigation, they ignored part of it and tried to justify the rest. Allegations were as follows. Conflict of interest. 4 years after he appointed as a judge, he still introduced himself in his LinkedIn page as owner of a law firm. And at least in the first year, I found 14 cases with self-represented litigants, which none of them were successful. After the first year that I complained, I didn't see any other judgment of him in the system. I don't know why they don't put his judgments in the system again. Abuse of power. I asked the court for audio tape and court transcript of my court hearing. But he directed the court not to release it because he told that I want to use it for complaint against judge. Why? He knew that under section 63 of Judges Act I have rights to complain, but he was aware of his misconduct. In Ontario, court reporter is mandatory when there is a self-represented litigant in the court, and only restriction to release audio tape and transcript is in family court and when a child is involved. It is interesting that in court I have been told that I can ask Judicial Council to release it, and Judicial Council informed me that I have to ask the court for it. Also, in another, he taught and wrote in paragraph 3 of his endorsement that he has power to dismiss the action even in the presence of a genuine issue requiring a trial. Judges must be impartial and objective in the discharge of their judicial duties. He was not impartial in this action. He denied 100% of my evidences such as affidavits, cross-examination transcripts, and evidences in my favor in defendant's affidavit and submissions. He denied my statement of claim as well as my factum. He accepted all false submissions and lies of the defendant while he knew and admitted in the court that they are lying. He went far more than the defendant and accepted and added allegations which the defendant admitted it is wrong and or does not exist. The defendant could not defend the action better than he did. Judges have a duty to follow the law. I explained in 30 paragraphs that he ignored the concept of common law system as well as many provincial legislation and Canadian Constitution. Lying under oath. A judge is always under oath in the courtroom. I explained in 35 paragraphs that with respect to court documents and his own submissions, he lied more than 20 times. Lying under oath is also serious crime which by law may have up to 14 years in prison. Cost and fraud. The judge reversed cost order of other judge, awarded cost for defendant's delay, awarded costs out of his jurisdiction, and moreover and amazingly changed the cost submission by defendant and raised it by 65%. He tried to punish me with huge cost award. It is also interesting to note that the most important evidence of judges' misconduct which was investigated in precedent cases as well is audio record. But in my case, Judicial Council, in clear support of the alleged judge, refused to investigate audio record even when they knew judge didn't release it because he was aware of his misconduct and didn't want to use it for complaint.